Leading our bulletin this half hour, the city of Cape Town will have to wait a bit longer before appointing a new mayoral committee. This as judgment has been reserved in the Patricia de Lille court bid to remain a DA member and mayor of Cape Town. Following today's hearings, de Lille says she believes she's still the mayor of the city. De Lille's legal counsel, Dalimpofu, argued that his client's right to be a member of a particular party is being infringed upon. There was a significant show of support for her, with an EFF leader saying de Lille is welcome to join their party. The Democratic Alliance on Tuesday rescinded de Lille's party membership, which resulted in her removal as mayor of the city. Meanwhile, the Independent Electoral Commission is interdicted from filling vacancies in the mayoral committee. Now joining us on the phone line is Valid Brown, attorney at Vakman's Attorneys. Now, perhaps to start on today's heads of argument. Now, the phrase "the horse has bolted" was used in the argument around the interdict. We also saw or heard the legal rep of the DA. He argued that a wrong has happened. She's been removed. We all understand the purpose of an interdict is to preserve the status quo. But then we had Dalimpofu coming and saying, well, if someone is suspended, they're given a time frame to prepare for that. It doesn't just happen. What was your take on just that argument alone?
Yes, good evening to you and good evening to your listeners. Obviously, my understanding of the matter is entirely based on the media reports. But what I understand is that the entire issue is about whether or not she's entitled to an interim order at this stage. And the argument on the part of the DA was that it's too late. The horse has bolted is the phrase that they used in court, in the sense that they've already committed the deed of removing her as mayor, and an interim order can't return her. The argument on the part of de Lille and her legal team was that it doesn't just occur like that. They don't necessarily accept that she has been removed as mayor. She still sees herself as mayor, but they want the court to confirm and indicate to all third parties, including the Speaker and the provincial parliament, that she is still mayor, at least until the second part of her application is heard, I think, in 2 weeks' time.
Mm-hmm. But then around the tensions, though, I know that Dalimpofu argued that these tensions within her caucus have existed for the longest time, actually a year, and that for that, it cannot be said that it rendered governance by the city dysfunctional. Another 5 weeks would not make a difference. But it seems that they are adamant that she has to be removed.
Yes, in fact, that was one of the questions posed by the judge, Judge Campbell. When they were arguing the issue of urgency, the first thing that de Lille has to overcome is to prove to the court that the matter is in fact urgent to warrant an interim order. And when the DA was saying that it's not urgent, that de Lille will not suffer any prejudice because the act has already been forked, she can just wait another 2 weeks. The judge's question was, what is the prejudice to the DA? Because the position that you have found yourself with your member, de Lille, has existed for more than a year. What has changed in the last week? And I'm not sure that the counsel for the DA answered that particular question adequately. Because the question the judge will have to weigh up when he considers the order is whether the prejudice or the harm suffered by de Lille is outweighed by the harm or prejudice suffered by the DA.
Mm-hmm. Because another issue that has to be considered is governance, which talks to service delivery. That if you have now an interim mayor or mayoral committee come in, they make decisions. If perhaps we have a judge rule in de Lille's favor, we might have to have those decisions declared invalid. And now that is a problem.
Absolutely. It interferes with service delivery. It interferes with the proper governance of the city of Cape Town. And to be honest, as you know, the DA has always held up their governance in the city of Cape Town as the crown jewel in the party's cap. And to see them prejudice that governance to this extent is quite shocking for the average man to see.
And then to the most contentious, the party's decision to invoke that clause on the cessation of membership. Now, this remains the argument. I've read their constitution where they say if one goes on to declare publicly their resignation, then they officially have resigned. But my understanding of that transcript or the interview itself is that there was an event to precede the resignation, which was her saying that after the outcome in court, once I clear my name, I will resign. So this was based on a future event and possibly even the outcome of that future event, which hasn't occurred as yet. So why would that be taken as a resignation if she has said, after my disciplinary process, I will resign, not now?
Well, you see, that's a very interesting point. The interview and the answer given by Lille in that interview is certainly open to two different interpretations. On the one hand, she did use the words, I will walk away, in answer to a question. But it can also be argued, as you correctly said, that that is only in the context of a precondition having taken place, i.e. proper disciplinary procedures or the court procedures having been finalized. Then she is prepared to walk away if the procedures have been completed. It is quite interesting that the DA decided to use this route. I mean, one knows that there are various options available to them to try and remove someone in the position of a mayor. There's, of course, the option they did first try, and that's the vote of no confidence. There's the internal party disciplinary processes. They appear to have abandoned both of those options for this, what I deem a lesser option, an option that's much more open to challenge. I also believe that in the Lille's papers, she actually cites various other examples of DA members publicly stating that they will resign and the party not having invoked that section, which then leads to the argument that is the DA applying that particular section fairly even-handedly to all members, or is it only particular members?
Now, it's often stated that political parties as autonomous bodies must be aware that their constitution will still be subjected to our South African constitution. Do you see any consistencies here in respect of the DA's constitution against ours? Because, I mean, they talked about her asserting her right to be in office as elected by the mayoral committee, and her right to be a member of a political party. I heard the judge saying, no. She doesn't have a right to be a member of a political party, or at least the Democratic Alliance. She can be a member of any other party. But do you see any inconsistencies there where many want to say we are an autonomous body, but they forget that they are subjected to our constitution?
Yes, look, I mean, the high courts in the country have previously found that political parties are private bodies. To that extent, I think they have a point. But on the other hand, it is correct, as Advocate Mpofu argued, that there is a section in the Constitution that says each citizen of this country is entitled to be a member of a political party. The point the judge was making is that it doesn't necessarily have to be the Democratic Alliance. But in the law's argument, what she was saying is that I was a member of the Democratic Alliance. You can't just take that away. It was my choice to be a member of that party. You can't just unilaterally take that away without giving me a proper hearing or an opportunity to explain myself. Now, to the extent that there's a conflict between the South African Constitution and any political party's constitution, I think this judgment may clarify certain of those issues.
Let's talk about the implications for both parties in this dispute. I mean, if the High Court were to rule in Patricia de Lille's favour, what would that really mean for the Democratic Alliance and vice versa?
Look, at the moment, the only issue before the court is the interim order and the issue of urgency. So if they rule in favour of Patricia de Lille, all she will do, she'll be reinstated as mayor for the 2-week period. Then, I think in 2 weeks' time, Part B of the application will be heard, and that is the issue as to whether the clause that is being invoked in the Constitution of the Democratic Alliance, whether it is being correctly applied, and whether or not she's been given a fair opportunity to be heard, or whether that should be reviewed. So that is a substantial part of that of the application. But any success for Patricia de Lille in this matter will be seen as yet another nail in the coffin of the Democratic Alliance. This entire history of various political commentators have commented that the way the Democratic Alliance has handled this process leaves a lot to be desired. So any loss, even on this issue of an interim order, will be felt very hard by them, I think.
No, certainly. I think on a political front, they're already feeling the pain. But let me put you on the spot. Just judging from today's arguments, where do you think the judge could go? Do you think Patricia, as confident as she is, could actually win?
To be honest, it's a very difficult issue. If Patricia is not granted the interim order, I don't think that is going to detract from the merits of the main part of her application. It's only a 2-week period. On the other hand, the judge may argue, or the judge may find that the prejudice or harm to be suffered by the Lille outweighs that of the Democratic Alliance, and may grant her the 2-week reprieve to reinstate her as mayor pending the final argument. It could go either way at this stage.
But then the cessation clause itself, do you see any prospects there? Because I've spoken to a number of legal experts, and some are feeling that no, the DA won't win this one.
Look, it does not appear from the outside that they are applying the clause even-handedly. The clause has to be subject to judicial scrutiny as it is being now. And once it comes against judicial scrutiny, the clause may be found wanting. It appears that they are applying it unilaterally, and it appears, as I've previously said, only to have been a third option in order to get rid of the mayor. We must remember that they only invoked this clause, I think it was this week.
Yes.
Their attempts to get rid of the mayor precedes this by almost a year. So it seems that the process was started a long time ago, and then they jumped on the clause and applied it and unilaterally terminated her membership. And I think the judge may have a problem with that.
No, it remains a very interesting time in the legal and political space. Mr. Brown, thank you very much. That's Vakman's attorney, Walid Brown, talking to us on the court proceedings from today on the Patricia de Lille matter.